Good afternoon, everyone, and welcome to the Orange County School Board's work session, which had been scheduled today for the purpose of discussing the following board policies: GCQF, suspension and dismissal of professional staff; GDQD, suspension and dismissal of support staff; and IJOC, school volunteers. The public will have an opportunity to participate in this will not have an opportunity, to participate in this work session, to provide public comment. Because this is not a regularly scheduled school board meeting, no action will be taken, and there will be no pre-agenda comment period in which the public normally addresses the school board on germane topics that are related to the work of the school board. The public will have an opportunity to provide input at future rule development workshops and subsequent school board meetings. Thank you so much for those of you who are joining us this afternoon. As a reminder, face masks are required indoors on school board property, which includes the boardroom and lobby. Board members are attending in person and telephonically. So let me take a quick roll call. Member Gallo?
I'm here, Madam Chair. Thank you.
Very good. Member Lopez? I believe Member Lopez is
Good afternoon.
Oh, you are with us.
Good afternoon, Madam Chair.
Good afternoon, Member Lopez. Member Cobert?
Good afternoon, Chair.
Vice Chair? Member Felder?
Good afternoon.
Dr. Casterdental? Try one more time. Dr. Casterdental? I believe she is going to... Oh, there you are. You with us?
I'm here. I can't tell if you can hear me.
We can hear you. Thank you. And Member
Okay,
Byrd?
great.
Good afternoon.
Good afternoon. All right, I want to remind the public that board members will not be engaging in outside electronic or digital communication during the meeting so that we can focus our attention on the meeting itself. And should you wish to contact us, continue to do so before or after the meeting. To my fellow board members and district staff, when speaking, please speak directly into your microphone and make sure that it's turned on so that our viewers on YouTube or Orange TV can hear you clearly. We're going to begin with a moment of silence, followed by the Pledge of Allegiance. And now the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, let me turn the meeting over to Dr. Jenkins.
Thank you, Madam Chair, members of the board. Today we're going to talk about our professional and support staff policies regarding suspension and dismissal, and then also cover our school volunteers policy. Topic really is around, if you recall, some discussion in the past, and the chair actually had requested a work session around some of the efforts we make around criminal background checks and disqualification and appeals for employment, and then that we employ those same standards for school volunteers. And so we brought the actual policy forward. I believe there's probably at least one thing we can add to policy that will help direct staff and direct your CEO around how you would like for this to be handled. I'll make those comments at the very end, but it's a good idea for anyone listening and for the board to hear the background of what we currently have in place. Mr. Palmerini.
Thank you, Madam Superintendent, members of the board. Those three policies that the chair listed off, I'm going to go over briefly what's in them just so we have an idea as to what the actual standards are. Policy GCQF deals with suspension and dismissal of professional staff. That's your administrators, that's your instructional staff. And subsection 5 says any falsification or material misrepresentation within an employment application shall be considered misconduct and may be regarded under these rules as cause for termination. As you see there in parentheses, it's the same standard that we employ with respect to our volunteers as well with respect to falsification. Policy GDQD is suspension and dismissal of support staff. And it says a recommendation for dismissal of a member of the support staff shall be based on one or more of the reasons set forth in policy GCQF, suspension and dismissal of professional staff. What this essentially means is if a support staff member is found to have falsified an application, it shall be considered misconduct and it may be regarded on these rules as cause for termination. And then we have policy IJOC, which deals with volunteers, which says all volunteers shall be registered and approved through the additions program according to district procedures. That's normally the superintendent and her staff have set up procedures about how we bring volunteers into the system, and that's what the board policy would require. So now, this is the Orange County Public Schools Employment Services hiring statement. And this hiring statement guides how we hire our employees. And it tells the folks, it's something that our folks who apply for employment, there is a pop-up where they can see this hiring statement. And it tells the applicants various things. One, that there'll be a criminal background history check completed, and that will be done by fingerprints for employees. We remind them that the arrest records is revealed to school districts, including for records sealed or expunged. There are specific Florida statutes, 943.0585 and 943.059, that allows school districts to have access to sealed and expunged records. The reasoning behind that is we employ folks who have access to children. Usually they are not supervised when they have access to those children, so the legislature has wanted us to have the full and complete record of this potential employee's background when making a hiring decision on whether or not to hire them. We informed applicants that they must disclose the records, even sealed or expunged records, even if told differently by a lawyer, judge, or other law enforcement individual. Now, what we have, in going through this process, we have told you that, and Ms. Enval had to do that when she was working for judges, is that these sealing and expunction orders will say this will not be applicable when you're applying to various entities, including a school district. So they will inform you right in the order that you will have to disclose a sealed or expunged record if you apply to work for a school district. So prior criminal history, and we say this explicitly, prior criminal history may or may not result in disqualification for employment. So the fact that you could have criminal history doesn't mean you're automatically disqualified. But then the next sentence is important. However, failure to disclose this information will disqualify you from employment. So it's an explicit statement that if you fail to disqualify, and it comes up on the background screening, that we will not hire you. And we say that this information must be disclosed, including any offense that occurred, whether as a juvenile or adult. We also have access to juvenile records. For the reasons I stated previously, our employees deal with students, many cases unsupervised, so we want to have the full background of the employee when we make a decision whether or not to hire them. So we also say, what's the criminal history include? Any offense for which the applicant posted bail. Posting bail means you've been arrested, so that would be part of your criminal history. Any entry of a pretrial diversion or pretrial intervention program. In order to get in those are usually for first-time offenders, and you have to tell folks that you have to admit to the court in order to get into those programs that in fact you have committed the offense of which you're charged. Now you go through the pretrial diversion program and then eventually the charge gets dismissed, but you have to take responsibility for your actions in order to get into those pretrial diversion programs. So we also say you have to disclose whether you've been to teen or drug court or juvenile programs. You have to disclose whether or not adjudication was withheld on a criminal offense, whether you've been convicted or found guilty, whether you were placed on probation, whether you pled guilty or no contest. Just for your reference, and for those of you, I think Ms. Colbert and Ms. Gould were on the board when we had a case with an employee who pled no contest to a child neglect charge and adjudication was withheld. And she said she wanted entitlement to her job back, and we said no. Adjudication withheld and a no contest plea is a conviction under Florida law. And that's that little note at the bottom of the page that says if you plead no contest and adjudication was withheld, it's still considered under Florida statutes to be a conviction. So, and we also ask if you were ever jailed or imprisoned or appeared in court as a juvenile or an adult. And again, we tell them that sealed records, expunged records, and military court proceedings must be disclosed. Another note with respect to sealed or expunged records, and I believe Mrs. Gould brought this up. With respect to sealed and expunged records that we get as a school district, there is also a statutory prohibition in 6D of both of those statutes that says when we get those sealed and expunged records, we cannot disclose them in response to a public records request. So if somebody made a request for an employment file of an employee who has a sealed or expunged record, we are prohibited from disclosing that. So that is another point of information for people who are fearful about disclosing their criminal, their sealed or expunged records, thinking it's going to be public record. It will not be. So, and we also note here that you have to disclose DUI and reckless driving because those are technically felony charges under the statute, so you would have to disclose those when you would disclose. Normally we say we don't want you to disclose minor traffic incidences as part of your application, because minor traffic incidences that are just traffic citations are not really they don't really come into play for us, except of course if somebody is a driver and they're applying to drive with us as like a transportation employee, then it may have some bearing on it. So now, this chart here also describes when we will not hire anybody, when we will not hire them if they've had a conviction, or when we will consider it on a case-by-case basis. So Florida Statute 1012-315 has a whole list of offenses that if you are convicted of those, you are disqualified from employment with a school district. It's everything you would think it would include: murder, sexual assault, sexual battery, aggravated assault with a firearm, drug offenses if they are a second-degree felony or above. It's everything that you would think that would disqualify an employee from being a school district employee, and those are listed out specifically in statute. And so if you've been convicted of any of those, you are disqualified from employment. Now, there are disqualifying misdemeanors. Most of them are felonies. There are disqualifying misdemeanors. The one we are generally concerned with is battery on a minor. Legislature said if you batter a minor and you're convicted of that, then you don't have the ability to work in a school system for obvious reasons. We also say we will not hire you if you have a pending criminal or misdemeanor case. We tell you, get that case resolved, and then you can come back and apply, and then we will address whatever the outcome of that is in a subsequent application. But if you have a pending criminal case, we will not hire you until that has been taken care of and adjudicated, and then we will consider whether the disposition of that case after it's done. Currently, we will not hire anyone who has been convicted of a felony, if the felony is within the last 25 years. That's assuming, of course, the felony is not a disqualifying offense. If the felony is not a disqualifying offense, we won't hire you at all. For juvenile felonies, juvenile misdemeanors, and adult misdemeanors, we will not hire you if that offense, that conviction occurred within the last 5 years. That's the standard that we have employed. Now, case-by-case basis, we will look at a felony that's more than 25 years old. We will determine whether or not on a case-by-case basis to make that person eligible. Depends on obviously what the offense is and how long ago it was, and that's something that our folks will look at on a case-by-case basis. We will also look at a case-by-case basis for any misdemeanor that is more than 5 years old. So we will look at that to see whether or not we want to make them eligible, and that will usually be done through the appeals process, which I will describe later. And then finally, we will look very closely at arrest and charges for any crime involving violence, domestic violence, battery, etc., and or drug offenses within the past 10 years. And for arrest and charges, so I give the example that I think I've given to all of you beforehand. Let's say we have a spouse who is arrested for domestic violence. And, you know, many times what will happen in those cases is there will be an arrest. The other spouse will call the police, have the person arrested, and then, you know, the person will bail out, and then there will be, you know, conversations between the two spouses, and then the charges will end up being dropped. Well, if we see that happen 2, 3, 4 times, that might not be somebody we want to hire, even though they haven't been convicted and the charges have been dropped, because there's a pattern of conduct there. So we will look at that on a case-by-case basis. Drug offenses within the last 10 years. Obviously, we look at those just to make sure, you know, if it's a small amount of possession, that's one thing. If there's large amounts of possession, if there's trafficking involved, even if they are not convicted, we want to take a look at the circumstances surrounding those arrests to see whether or not we think this person would be eligible for employment with us and would be a good fit for working with us. And so now I am going to turn this over to our Senior Executive Director of Human Resources, Jim Preußer, to talk about our appeals and how those have been handled and what the statistics are on that.
All right. Can you hear me okay? Good afternoon. So, board members, on this slide, you'll find the data history on criminal cases. The first chart on the left shows you the criminal history cases. It includes the total quantity of people with criminal history who disclosed and were cleared versus those that did not disclose and asked for an appeal. I think the thing that I want to point out to you is when you look at the appeals and the cleared by disclosure, you can see that many applicants are cleared through disclosure based on the bar graph and the chart to the left. Let's talk about a couple specific years. So 2021 criminal history, so there were 153 that were cleared as they provided all documentation necessary. And we do ask for that documentation throughout the process, and I'll talk a little bit about that later on the 3 different ways that conversation might occur. Out of those, 20 did not disclose, and they went through the appeals process. 14 were falsification, 6 were other, and 1 of those was overturned through the appeals process for a total of 173. 2020, 196 were cleared as they provided all the documentation needed, as I discussed earlier. 31 did not disclose. They went through the appeals process. Out of that 31, 17 were falsification, 14 were other, and 4 of those cases were overturned for a total of 227. I would like to note that other cases included in the data include criminal history such as recency. So, if it's 25 years, less than 25 years, or 5 years within the last 5 years, felonies, nature of the offense, etc., as we've talked about the different hiring guidelines. So we've talked about this before, but all candidates have 3 opportunities to disclose, and I'm going to talk about each one of those. The first one is the application in ISEMS, and that would be the application that the employee fills out when they're trying to acquire employment. The criminal history update form, which is also known as the last chance form, and we'll get into that. And then a conversation with an HR compliance coordinator. So in the next slides, I'm going to walk you through each one of those opportunities that an applicant has. So the first one is the ISEMS employment application. As you can see, and John spoke to us earlier, there's a series of questions that the applicant is asked, and those questions speak to seal or expunged, records or criminal offenses recorded. So as you can see, the employee has an opportunity to answer yes or no. And then I would also point out that at the end, you can see the bolded and highlighted section that speaks to failure to respond truthfully will be considered falsification of your application and may result in your ineligibility for employment or may result in termination of employment. So try to be as bright line and as clear as possible through the process in the application. The next section here is the criminal history update form. And so there's a couple things that I want to point out here. So in the pre-O sessions, the facilitator actually reviews this slide with the potential employee. As you can see there, we will not hire, and John spoke to this earlier, felony convictions less than 25 years or any conviction within 5 years. Open cases, any criminal history that was not disclosed. Failure to disclose criminal history is a disqualifier. And the one thing that I also want to point out is the language up there that I just moved into sight. And I'm going to read it to you just because it's very important. And it is, I want to point out, it is reviewed by the facilitator in the pre-O session. They do speak to it. And they also advise them that you must affirm and acknowledge the fact that this statement is available to you. So in Florida, all criminal history must be disclosed on public school district employment applications, no matter where it occurred, which is very critical. That's a critical element to that statement. Or what you've been told by a judge, lawyer, or other third party. All juvenile and or adult issues must be disclosed. Failure to disclose criminal history that is revealed through fingerprinting will disqualify you. In Florida, all criminal history is reported to school districts, and John spoke to this earlier. Fingerprinting is done for the purposes of doing a national criminal history background check, which is our level 2 background check. So again, that is something that we really focus on during that discussion. The next element in the third, for the 3 discussions, or 3 opportunities, I should say, is a private conversation with an HR compliance coordinator. So sometimes a candidate or an applicant is unsure about how to complete the update form, the criminal history update form in the PRIO session. And if that's the case, and that's the scenario, because they may not know, well, what am I supposed to write down? Maybe this happened 40 years ago. What should I be doing? They have a private conversation with an HR compliance coordinator on the fingerprinting team. And then prior to fingerprinting, everything is pretty much held at that point in time. So if there is criminal history that they disclose, they do not move forward with the fingerprinting. Again, it is stopped, and we pause at that moment in time, and then we ask them to submit the necessary and appropriate documents based on the situation that's described. This next slide, we just want to illustrate here that on average, based on the history update form that we've had in place for some time, it saves approximately 50 to 60 applicants on an annual basis. And next, I'm going to turn it back to John to talk a little bit about the volunteer.
Thank you, Jim. The volunteer registration and screening process, this is our e-recruiter page where you go in online to register yourself to be an additions volunteer. We have gone through standards on what we wanted to do with volunteers for a long time, and in the late 90s we had a task force that looked at this and said what kind of standards did we want to utilize with respect to our volunteers, and we largely decided to mirror it on what we do with employees, again, because those folks can have access to children, and in many cases it could be unsupervised by a district employee. We also had the passage in 2007 of the Jessica Lunsford Act, which arose out of the tragedy with respect to that little girl who was killed by somebody who had access to her. So that required more extensive background screening of folks who are going to have access to children on campus. So we have implemented a lot of that into our volunteer process. And with respect to criminal history, they have numerous places where they can disclose and where we give them the opportunity to disclose their criminal history. We have a volunteer background consent statement. We have a volunteer eligibility statement. We have a volunteer application, a volunteer profile update. For those of you who have ever gone on field trips with your children every year, you have to update your information every year and sign up through our system to become a volunteer. That way, and you have to update your criminal history background when you do that. So you haven't had anything in the last year criminally that would disqualify you from being a volunteer. So that is also something that we do. And then the appeals process, which I will describe in a bit. The volunteer background consent statement, and attempting to read this with my eyes is going to be difficult, so bear with me. This is what is presented, and somebody has to certify when they apply to be a volunteer, when they authorize OCPS to perform a criminal history background check. It said, it's the policy of the School Board of Orange County to conduct criminal history background checks for individuals who participate in volunteer activities. If criminal history is revealed that was omitted from your application, you will be disqualified. In all caps, you must disclose all criminal history. So they have to read that statement and certify that they've given us permission to conduct the background screening. We also have the volunteer eligibility statement. And again, that volunteer eligibility statement mirrors the employment hiring statement that I described earlier in the presentation, where they talk about we have access to sealed and expunged records. Again, requires them to disclose their criminal history. Again, tells them that while you may have a criminal history, that's not necessarily disqualifying. If you fail to disclose it, it will be disqualifying. And the chart there indicates that we will disqualify volunteers on the same basis that we do applicants for employment. If they're convicted of a disqualifying offense, they will not be allowed to volunteer. If they have a pending criminal matter, they will not be allowed to volunteer. If they've committed a felony within the last 25 years of which they've been convicted, they will not be allowed to volunteer. If it's a juvenile felony, a juvenile misdemeanor, or an adult misdemeanor, they'll be disqualified within the last 5 years. And then the case-by-case basis, the conviction that's more than 25 years old, if it's a felony, or 5 years old if it's a misdemeanor. So these forms are presented to them. And what happens is they will go through and they will fill out the application, and they could be disqualified on the basis of their criminal history for one of these reasons, or because they didn't disclose criminal history. So then we have an appeals process. This appeals process has, works or is applied to both employees and vendors, or not, excuse me, and volunteers, excuse me. And what happens is if somebody wants to volunteer, they have to disclose various pieces of information. First, they have to talk about their criminal record. If their criminal record was at issue, they had a disqualifying offense that they didn't disclose, they're going to have to talk about that. They're going to have to talk about their work history. So, for example, and I've used this example, I think, with all of you in discussing this previously, if an employee was fired for embezzling funds from their employer and they wanted to volunteer with their child, we would not allow them to volunteer in the front office helping the secretary bookkeeper, keep our books up. That would not be something we would do with that. So we would go into work history to make sure we have a full picture of who they are, why they were fired from employment. Reference letters. We will have reference letters from various folks. We see them all the time from college professors. We see them all the time from, religious figures, pastors, priests, that says, I know this applicant, they're a congregant in my church, or I know this applicant, they were a student in my class. I think they would be great for employment or for volunteering. I understand they have this past criminal history, but I think they've gone beyond that. They've done the work to repair the circumstances in their life that caused that, and I really think you should hire them or allow them to volunteer. And then an appeals rationale. If it's failure to disclose the criminal history, why did you fail to disclose the criminal history? Is it, my God, that was 40 years ago and I completely forgot about the offense, or I didn't realize I had to disclose sealed or expunged offenses? We're going to treat some of that a little bit differently. But obviously, you've seen here that we tell folks that they have to disclose sealed and expunged records when they apply to us. So then we have the executive appeals team. All that information that was just collected will go to our executive appeals team. Ms. Enval sits on that. Our Director of Employment Services, Stephanie Herron, sits on that. And our Director of Talent Acquisition and HR Compliance, or as I've recently learned, they are known as TAC. That's the acronym for it. That is Pani Toffoli, who will sit on that appeals committee. And they will take extensive looks at all these folks who appeal, and they'll go through that work history, the criminal history, the references, and the appeal rationale to determine whether or not the appeal should be approved or denied. And then finally, I want to turn it back over to Mr. Preußer, whose department has collected some information on what other Florida districts do with respect to these background checks and background screens and how they treat falsification.
All right, thank you, John. So you have the illustration in front of you, and we do, as we typically have done in the past, reach out to other school districts to determine what exactly are you doing with respect to this particular topic. So with respect to hiring guidelines, we had an opportunity to reach out to these different districts. As you can see, we're identified in the column that says orange. Of the districts who responded, we're the only one that offers the second chance to disclose criminal history. You can certainly look at some of the other districts to determine how they've answered or how they address that particular situation. I will tell you, though, that many of the school districts they were interested in our second chance form. They weren't aware that we had that, and they wanted more information. Most specifically, Miami-Dade had some questions about it and wanted to know what our process was, and we're going to be speaking to them with respect to that. And then the other three things I want to identify is there is a not applicable NA in our column under timeline for disqualification. And the reason that that's there is because we have a permanent disqualification. That's why that's there. And then in addition, for Volusia County, Volusia is specifically following the Florida statute 1012-315 with respect to disqualification. If it falls within that category, John mentioned a couple of the areas where you could be disqualified, then obviously that would not be applicable in that case. And then the last thing, before I turn it back over to Dr. Jenkins, is the statement at the bottom there that says falsification of criminal background may result in denial or revocation of a teaching license by the Department of Education. So we wanted to make sure that that was clear because that can happen from time to time. And with that said, I turn it back to Dr. Jenkins.
Thank you, Ms. Preußer and Mr. Palmerini as well. Just a couple of notes for the board, and then certainly listen to any questions you might have in discussion. Number one, clearly we've been extremely cautious around screening of adults who are going to be around our children. It's understandable that we would be extremely cautious and careful, not only by statute, but ethically, a requirement, I believe, that we be extremely vigilant to screen those who will be around minor children. And I don't want the board to think I'm asking for direction at the operations level. I don't want you to be in the weeds, but I do want you to be aware of what's currently in place. Former General Counsel Woody Rodriguez actually helped codify that appeals process to make sure that we were as consistent as possible with those who had concerns around criminal background check. But at a policy level, I really do think the board could weigh in around this notion of timing. So if you failed to disclose a conviction or an offense, currently you are ineligible for all eternity. And I think we could probably go back and take a look at that at a policy level, because I think it's important to codify it in policy, and then that directs this superintendent, future superintendents, and future boards that there was an understanding, a provision made by the school board intentionally. So I think it could probably be along these lines, that failure to disclose a non-disqualifying, I don't want to open it up for if it was a disqualifying event anyway, but failure to disclose a non-disqualifying makes them ineligible for employment or volunteering for the period of 1 year from the time of their original application. After that time, then they may reapply for employment or for volunteering. And I want to be clear, because I don't want anybody to think, no parent to think somehow we're loosening our controls. Reapplying means you had something that would not have been a disqualifier, so you can start over. That doesn't mean we still would not be extremely vigilant and scrupulous in looking at whatever those issues were. But if it's a non-disqualifying event, I would like for policy to indicate you're no longer permanently ineligible to be considered. In a year's time, you may start over, you may start the process over again. There's not an automatic approval, but you may start the process over again and disclose that which came up in the criminal background check. I think putting that into policy helps make it clear to everyone there's an opportunity to come back if you say there was something really unintentional about failure to disclose. Again, it's a start over, a reset button. It is not an automatic approval, but it gives you at least a chance to disclose that and go through the process. That's really where I'm hoping we'll get some direction or some agreement from the board at the policy level. Again, I want to re-emphasize, I know I had a couple of board members concerned that we not give the impression that we are lessening the scrutiny that we place upon adults who are going to be working with our children. That is not what we're looking at all. We're simply saying if an individual, for whatever reason, failed to disclose a non-disqualifying offense, then we would let them come back after a year of their first application and start the process over again. Madam Chair, members of the board, happy to hear your discussion, answer any questions.
Thank you, Dr. Jenkins, and thank you, Mr. Preußer, and thank you, Mr. Palmerini, for the presentation. Great information in there. I know that the board had an interest in revisiting this after we heard from, surprisingly, we've heard from 4 different individuals this year. In the 2.5 years prior to this, I had never heard from anybody. I'm not sure about Member Coburn and Vice Chair about whether this has been something that's come to the board, and I'm not quite sure what changed the dynamic this year or if it's just a fluke. But as I delved into this more, what I find is even on the forms that we offer and that we provide, there are some inconsistencies. And not wanting to get into the weeds of operation, but I think it's important that whatever is presented to, whether it's employees or volunteers, is crystally clear and consistent. For instance, on the employment application, same application as the volunteer application, it says that failure to respond truthfully will be considered falsification of your application and may result in ineligibility. So, and may result in termination. So But on the other forms, it says it will result in disqualification. So I think at a minimum, we need to be consistent in that language. The second thing that came to me as I looked at this is when I try to read it, I want to say layperson, but I don't, just looking at it from the outside rather than all the time we spent on the inside, the term criminal offense is used throughout almost this whole thing. And putting myself in the shoes of somebody who is applying to be, in most cases, what we've heard from is people that want to volunteer free of charge to coach. And if you are asked, do you have a criminal background or have you had a criminal offense? If you were arrested, falsely arrested, the charges were dismissed, do you believe that you have a criminal offense that you have to disclose? I think if you just ask that without looking at this application, you just ask an average person, do you have a criminal background? If it was dismissed, my answer would be no. So I think that the terminology that we use also could be a bit more clear if we're saying, do you have any criminal records to disclose, might have helped to eliminate a little bit of this. Yes, there are time after time after time that's highlighted here, but there's actually, I think most of the cases that have come to us this year have been charges that have been dismissed, not expunged, not sealed. Expunged and sealed records would indicate that there was, in most cases, there was a conviction or determination that there was some guilt and it was expunged. Dismissed means, and dropped means it didn't go forward. So to say you weren't guilty, just say there's no way you were charged. So there's only one place where the word dismissed or dropped is used in all of this. The rest of it talks about criminal offenses, and admittedly, you should read every word, but it is the fine print words that are in here that deal with dismissed, I believe. Yeah, and it is a checkbox, but it is small print and it's one thing. I will have to admit, I hope I'm not the only person who has occasionally rushed through something too quickly and not gotten it perfect. And that's the part of the point of the appeal process. Also do want to mention that on the application form, there's a area for B6, but there's no box to check. And I don't know who, Dr. Jenkins, I'll just bring it to your attention. But B6, at least in what we're shown, doesn't have a box to check. So with the idea that supposedly our process right now is, and this is what I was told from the beginning when we heard from our first individual, I won't mention names here, but what I heard from staff was that we needed to ignore how compelling the case might be because we need to be consistent, and everybody who doesn't fill out everything right is falsifying and they're turned down. And we can't open Pandora's box. And then I discovered that that's not what we've done. This year in February, there was an appeal, it was upheld. And when I look at that appeal, some of the language that the person used on their appeal was, I forgot it happened 40 years ago. I didn't remember I was arrested. I've been a great person ever since. I have a wife, a family. I've proven myself. Similar to what I've heard from the other 4 people that have come before us. Either I forgot or I overlooked it. And so I really wanted us to revisit whether I forgot, I overlooked it, is a reason to ban somebody from stepping foot basically on our campus or helping our children in any way forever. And I also think even if we're going to put a time period where they can reapply, that everything is not equal. So if a charge is dismissed, a charge is dropped, or a record is sealed or expunged, and I asked Ms. Emval if she could provide us a little bit more information, because my understanding of expunged records is those are usually minor offenses, generally committed by juveniles or young youth. They're minor enough that there is some sort of restitution that's paid. And is that somebody, do we need to have a disqualification requirement in there for something of that nature. So, and if we are going to have a 6-month or 1 year, you can come back, does that also apply to somebody who was found guilty, spent 5 years in prison, and failed to disclose? I think that's a little different. I think anybody who has served time for an offense didn't forget that they have a criminal offense. And it would be hard to believe when they're looking at this form that they wouldn't remember, and I'm not trying to discriminate against people that have served time in prison. I am a big believer in giving people that come out of jail or prison an opportunity to get back into our workforce and to become productive. I believe strongly that we have to do that, but I think that there is a different, if I'm filling out a form that says, do I have a criminal offense, if I know I've spent time in prison, not waiting trial, but as a consequence, I know I have a criminal offense to report. So I think from a terminology standpoint, there may be some legitimate confusion. In one case, and I'm not sure if you all got the same communication, I think you all did from, I'm sorry, do you know what I'm talking about? Okay, I'm not sure what we're talking about. No. I was talking about a particular individual who hasn't come here but wrote to us. And I asked for his permission to explain the situation. I'm not going to use his name, but in his case, the situation occurred 44 years ago. He was, okay, you got that, yeah. And so I looked at that and I'm like, okay, that would be one. I think if I were sitting on appeals committee, I would go, has some merit. And when I looked at the list of roughly 20, 25 over the last several years, I saw several like that. So I think even what we're doing right now, I would argue is not 100% consistent. It's not what I heard from staff in the beginning. And I believe honesty is really important. But I could even argue whether I was told the truth. I don't think I was lied to. I think that whoever told me this is what we've always done, believed that to be the case and made a mistake. And there's a lot of grace that we give in this world and in this organization. I never want to put our children at risk, but if the offense for which we're discussing would have no bearing on their ability to sign up and coach in a supervised manner, had nothing to do with violence or anything against children, I would strongly suggest that we revise this. And as the superintendent has suggested, I would be fine with a wait and reapply approach. But I do want us to be very kind of careful about what would be eligible for what time period and look at that a little bit more carefully than I think we will have time to define today. So with that, let me turn to Member Byrd.
Thank you, Chair. I have a couple questions. The 25 years and 5 years for felony misdemeanor, where does that come from? Is that anywhere in statutes, or and also my second question to that is that what other school districts do typically? Is that kind of normal?
There were revisions to these standards, I guess, back in 2012, 2013, and that's the number that came up, that committee that did the revision to this came up with. It's not statutorily based. Sorry, forgot I had the second one on. Apologize. The committee that revised this came up with the 25 and 5, but it's not statutorily based. With respect to other school districts and how they handle that specific disqualification issue, I didn't look into that, and I think Mr. Preuss's folks didn't look into that particular issue. I'm not quite sure of the answer to that.
That's okay. I mean, if it was done by a committee, I'm sure that they looked into that. My concern was just with the misdemeanor. You know, those can be fairly typical kind of, 5 years is a long time, I think, for a misdemeanor, in my opinion, but I guess it would depend on what it is. I have another question about the difference in, can you explain the difference in the background checks that are done for employment as opposed to volunteers? Because I know volunteers are not fingerprinted, correct?
That's right. Volunteers we get their social security number as part of the application. So what we do is we run the social security number up. We'll go through the FBI, we will go through the Florida Department of Law Enforcement, run the social security number, and they get the background screening back. Whereas with employees, we actually fingerprint them. Fingerprinting's done every 5 years. So we'll fingerprint them initially when they come in, and then we'll re-fingerprint them again in 5 years, or run the fingerprints again, just to make sure that no criminal history has come up. But we also have with employees, if they're supposed to self-report any arrest or charge within 48 hours under our management directive, if that were the case as well.
And to follow up on that, what is the difference as far as the amount of information or the type of information you get between those two different background checks?
I'm gonna probably
You know
have
that?
to turn that over to Jim, and it's not very different, but give me 1 second.
So with an additions volunteer, we receive state data only. About once a year, we submit 400 random applications.
This is Keith Card, who does our fingerprinting. He's gonna explain it.
Thank you.
Mr. Hart, welcome. I think I've seen your name
Hart.
on an,
Card.
Hart, okay.
Good
Thank you.
afternoon, Madam Chair, and board members, and Superintendent Jenkins. My name's Keith Card. I'm a senior specialist responsible for criminal history compliance, badging, and fingerprinting. So as John was saying, thank you very much. So as John was saying, we capture fingerprints upon hire and resubmit fingerprints every 5 years. There's some legislation that's coming down the pike that's going to change that, where when somebody is hired, we can retain their fingerprints for the life of that relationship. Because if they go on vacation to Michigan in the summer, we might not currently know about an arrest unless they self-report, or on the 5th year when we resubmit those fingerprints. But I want to talk to specifically Board Member Byrd. You had talked about 5 years. We had studied when we had revised the current guidelines in 2017. We had talked to all 66 other school districts in the state, and then we also went to the top 6 school districts in the nation, including New York, Los Angeles, and Chicago. We looked to see what the big guys were doing. And when our panel discussed 5 years, we argued that oftentimes in a misdemeanor case, you could be burdened with a repayment plan over a 5-year period for a minor misdemeanor. And if you miss one payment, you're in violation of your probation, and you could be hauled away. They could come to school, arrest you, and of course then we're disrupted, having to get a substitute or perhaps even replace you if you're jailed.
Thank you. That's a
You're
very
welcome.
good explanation for that. Can you also, while you're there at the microphone though, can you, because I heard you telling Mr. Palmerini, but I couldn't quite hear what the difference is in the level of information between the volunteers and employees.
My apologies for that. Thank you very much. So with our additions volunteers, we do a statewide criminal history background check, just Florida Department of Law Enforcement. As John said, we capture some demographic information and social security numbers and submit that to the FDLE. Periodically, well, actually once a year, we do about 400 random additions people to a national background check. Economically, it's just very expensive to do it, and because volunteers aren't paying, we only do about 400 a year. And we do a cross-section of individuals from elementary schools, middle schools, and high schools. The difference between that and an employment criminal history background check is, with a criminal history background check, it's fingerprint-based, and we search all states and territories, and of course the state of Florida. And sometimes we even get some international information.
Thank you. As much as I understand the cost issues, that kind of makes me a little nervous. If volunteers are still in a situation where they can be alone with students, unsupervised, then I have concerns about not doing a full background check. So my thought is maybe there could be a different kind of background check done for volunteers that are in a situation where they are tutoring one-on-one as opposed to chaperoning a field trip. Just some thoughts. And then, I agree that we do have to show some grace, but I feel like the checklist on the first application is pretty self-explanatory, whereas it asks, have you ever been charged, including a charge which was later dropped. So I feel like that's pretty self-explanatory. But with that said, I do agree with the superintendent that I think that permanent disqualification is not really necessary if it's especially for a case that may have been dropped and they just didn't think they needed to disclose it, or they forgot, or they just made a mistake. I understand that, we want people to be as truthful as they can be, obviously, and we look for that in employees, but to never be able to work with children because they forgot to put something on that would not have stopped them from employment had they put it on, I think is a little bit unreasonable. So I would be in favor of looking at that policy as well. Thank you.
Thank you, Member Byrd. Member Colbert.
Thank you, Chair. I agree with you that there's probably a little room to take a look at those forms. It could be made very clear that disclosure includes anything that is dismissed, expunged, or adjudicated, that all of that counts. So there's probably a little room to look at that. But in looking at the presentation, also in the hiring guidelines, some of the disqualifiers, do sunset after 5 years. So to have it as a permanent disqualifier when you did not disclose, and shoplifting a swimsuit at 15 and not disclosing that is very different from not disclosing a domestic violence charge, even if it were dismissed. So I would agree with the superintendent. There should be a period where you are unqualified, but I do believe in allowing that to sunset and letting you disclose it, because if it was something that would not have prevented you from being hired, we could potentially be losing out on some good people. So the fact that we have had a few this year come forward is unusual. I can't really remember in the past 7 years having any others. So it is unusual, but perhaps that's what's brought this to our attention. So I agree with the superintendent's recommendation.
All right. Thank you. Member Castor-Dental.
Thank you very much. I appreciate this discussion, and I support looking at the forms again too for the internal consistency. And also, I like the superintendent's idea of the 1 year delay, or not making it a permanent disqualification for an offense that would not have otherwise disqualified them. And I think that's reasonable. I think it's fair. And I know that the cases that have been brought to me by people in my district, that would solve some of their problems as well, because some of them have been volunteers who have been disqualified permanently from participating in their kids' schools, and they didn't think that was fair, as they were parents of elementary students, and they thought, I'll never be able to go on a field trip. So I think allowing them to reapply for that volunteer status within the next year is appropriate. Thank you.
Thank you, Member Castor-Dental. Vice Chair.
I agree that we need to relook at the form. I also think we do need to, as Mr. Palmerini expressed my thoughts, really hyper highlight the fact that that it may not be disclosed to anywhere else, and that this is a state thing. It's still, I agree with you, Chair, in the way that it reads, not only the inconsistencies, but it's very punitive. And I'm also very concerned because not that long ago, we were looking at restorative justice. And the reason we were looking at restorative justice is we had a lot of what we thought were things that should have qualified for civil citation and not misdemeanor. And I think it's going to unfairly burden some of our youth, especially from the African American community and the Hispanic community, that seemed from the data to have a higher percentage of arrests versus, civil citations. And they would make excellent employees in the future, often doing, stupid things that young people do because they do stupid things, and not having that burden them. So I'd like to find that happy median where if we had somebody who was 40 years ago who may not even remember, and it may have even been expunged or never went anywhere, and they forget about disclosing it because so much life has happened, it seems out of balance to me. So I agree, and obviously background checks are our safety point on the flip side of that, to make sure that we don't miss anything that absolutely needs to be caught, so that we're not putting any of our children in harm's way.
Thank you, Vice Chair. Member Felder.
Thank you so much, Chair. Most of the board members and some of the things you said, and of course you introduced it, Chair Jacobs, I concur in that with the superintendent that we may need to be somewhat revisit that policy in terms of the length of time. And certainly I'm a proponent of so many times African American males have been given not just citations, but have been given sentences that will just felonies and so forth that have knocked them out on things that may not have been serious crimes, and they lose the opportunity to come in. And I've seen on so many examples. I was just recently reading about a gentleman who was in a gang and did all kind of crazy stuff, but he was now nominated a Teacher of the Year. Somebody gave him a chance. So certainly as an educator, we have to give a chance, but not forgetting the fact that the screening is so important, because we do have people in our society that are miscreant, and we cannot allow those kind of folk to be have our children exposed to those kind of people. The other thing, and I know we're talking about the hiring practices of volunteers and permanent employees, but I do have a concern, that may be a conversation for another time. Those persons that have already been hired, and there's some things that come up, and we do practice restorative justice with all kinds of things, even with our employees and so forth. So I'm hoping, and with our students, that we will take in consideration this policy again and go back through it with a sort of a fine-tooth comb to try to make sure that we give everybody an ample opportunity to do some things, because there is, people can change. They can change. I just wanted to share that with you all. Thank you.
Thank you, Member Felder. Member Lopez.
Thank you, Madam Chair. I am in support with the superintendent recommendations as well. I think that sometimes we have parents also facing similar situations, not having the opportunity to participate in field trips or becoming volunteer in their children's schools. So I think that this is a great idea. We even have individuals that have no probable cause, not having the opportunities to be part of the school system. So I think that this is a great opportunity to modify the policy as well. So thank you so much, and I just want to say that I'm in support of the superintendent recommendation, and I just want to support also school board member Bird. I believe the same way she thinks.
Thank you, Member Lopez. Well, let's come back to that for just a minute, because I know that what will happen next is that Ms. Enval and her team will work on drafting policy language. I think the superintendent would prefer that we articulate this in policy so that there's clear direction and clear consistency moving forward. But I anticipate that, for instance, Member Byrd brought up an important point, and that is if there are additions volunteers and they have direct unsupervised supervision, sounds like a contradiction, but her concern being that the background check that's currently performed may not be adequate. So, Dr. Jenkins, you might be able to fill us in a little bit more about the types of volunteers that might have unsupervised contact or supervision of our students, and whether you think that's already covered in our and are they doing a full criminal background check, or is that a gap that we might want to fill? I know that we're taking it in a slightly different direction, but if we're going to bring a policy back, we want to cover all bases.
So there's a statute. I'll remember this by the time the pandemic's over. There is a statute that says 10-12-468 that if they are in the presence of a level 2 background screened employee, they will not have to be background screened that way as long as they're in direct line of sight at all times. So those folks who are in, like say it's in a classroom and they're helping out like a homeroom mother or father, as the case may be, and they're helping out and the teacher's in there at all time, they would be in a direct line of sight, so you wouldn't have to background screen that person. They typically go through our background screening process anyways. We could have some field trips, for example, where, let's say we're going to SeaWorld. I'm just using that as one example where I've gone on, where I took a group of 4 kids around and I chaperoned them around. Or there's an overnight trip where the chaperone is staying in the hotel room next door and they're supervising. That would be a situation where they wouldn't necessarily be supervised at all times.
Okay, and to Member Byrd, since she's not here, follow up I think she was referring to not just having a state background check, but a national background check. Is that what you're referring to?
FBI trip, yes.
Okay, all right. So that, Ms. Emville, I think that's an area that you want to look at in terms of how we would revise it. And then I think then the other question I would pose to the board, if we're going to have kind of a sit-out, wait, come-back period, would it be the same regardless of whether the criminal charge was dropped, dismissed, forget the other term that somebody used, pardon me? Adjudicated. Would it be the same as if someone was found guilty, spent time incarcerated, and failed to disclose it? Would that be the same sit-out period? Would there be a sit-out period? And the reason I'm asking now is it's more efficient if we get some clarification of direction and come back with a rule development workshop, because if we come back and we make changes, as you all know, we start the process over. So any thoughts on that at this point in time? And I know it's not something that anybody had a chance to think about ahead of time. Ms. Emville, maybe this is something that you want to give some thought to, and the superintendent, and we'll rely on you to come back to us with some proposals.
Yep, in any event, we need to make sure, just like we have, make sure that it's consistent and clear for everybody.
Absolutely.
Because that's the consistency is what we need.
Yeah.
Madam Chair, and so to Amy's point, what I worry about is that restart button will end up going through some kind of appeals process, because I think mine is an extenuating circumstance. Vicki thinks hers is, you think yours is, and so unless we have an extremely detailed policy, I don't like that much policy, that much verbiage in policy. I'm worried about another bottleneck where everybody thinks they should be an exception. So we'll take a look at that. I want to be careful not to over promise that we can clearly delineate in policy language. Happy to take a look.
Okay. And I think kind of the direction that we were going is we want you to fill this form out accurately and correctly. If you don't, then you come back in 1 year and you try again. But as when I think about it, that might not be what we feel is appropriate for all level of offenses. So I do think there's a difference between not being guilty and being guilty, and forgetting that you didn't fill that out. If I'm guilty of a clear criminal offense, not a driving offense, a criminal offense, I'm probably going to be reading this carefully and getting it right, is what I'm thinking. Mr. Palmerini?
So let's remember here, if we have a conviction or a guilty finding, if it's a misdemeanor, they're disqualified for 5 years, and if it's felony, they're disqualified for 25 years, so there would be no appeals process. We're really talking about folks who have gone beyond those periods
Yes.
that you're talking about. Okay.
So to clarify, I'm thinking it's a misdemeanor, and you're beyond the 5 years. It's year 8. It's not disclosed. Does the board feel that that's an automatic, you get to come back in 1 year? Or does the board say, no, in that case, you should have disclosed it? That's where I'm trying to.
It's so
to the-
difficult.
Go ahead.
I see your point. It's just difficult to delineate in policy language, because all we're saying is you can hit the restart button, and then you're going to go through the whole process again. It's not an automatic acceptance. Restart means you get to come back and then go through that process. I don't want to try to delineate 3 years, 5 years, 25 years in policy. The notion is you forgot, you get to come back after a period of time. Now, if we want to say you come back after 6 months, if you're in these categories, and 12 months if you're in these categories, I think it's just going to get to be a little bit too wordy. It's going to be a lengthy policy, but I'm happy to take a look at it with council. But I understand your point is, should there be a difference in the wait time and the timeout? I want to make sure the board understands it's not an automatic get out of jail free or immediately go into volunteering or into employment. It's a restart to go through that screening process that's in place for the safety of children.
Understood, and thank you for that reminder that no matter what, there is still, you still have to apply, and you may or may not be accepted, depending upon all circumstances being considered. The one other thing I do want to mention, I think it was Vice Chair who brought up, I did not realize that this board had ever taken up, kind of discussed the issue of civil citations versus misdemeanors, and I wish I had known that, because, and it maybe isn't too late for us to try to figure out how to weigh in on this. One of the things that troubled me was when I learned that, and I think this is still the case, that some of our law enforcement agencies here in Central Florida and Orange County, it's up to the officer. If they pull somebody over and they have a small amount of marijuana, I forget the amount, if they have a small amount of marijuana, it's up to the law enforcement officer whether to look the other way or to cite them. And I found that really troubling, and I think some of my more liberal friends were frustrated at me for finding that troubling. It wasn't troubling that a small amount of marijuana might get a different treatment. It was troubling to me that that was an individual officer. I have huge respect for law enforcement officers, but I think that there's too much of a potential for there to be disparate treatment, and almost condoned by a system that we've created. So I didn't know that this was something on y'all's radar screen. The other thing on my radar screen while we're talking about our youth is, I think it is troubling to me, and I was trying to work with Chief Judge Lawson on this, was that children who have parents who have the means to have their children's records expunged can do so, but it's a very costly process, and it is, again, it's a great inequity for some people to have this scar that follows them through life because they don't have the money to go through that process. So I would always wanted to see that corrected. I think that maybe that is a legislative issue, I don't know, and maybe it's probably outside of our realm, but I know how much this board, I'm just thrilled to be on a board like this, where we share those common concerns for not just what happens in the classroom, but how our children's lives are altered by mistakes that all of us make along the way. Member Colbert, and then I'll go to Dr. Jenkins.
Yeah, Chair, I want to say, and help me, Member Gould, probably about 5 or 6 years ago, where the district really made an extensive effort to transition to the use of civil citation and the use of restorative justice to cut down on the number of our youth being arrested, and that was not solving the problem. And it would be great if they could give us some of the current statistics, but I know we had a dramatic drop in the number of children being arrested, and really with the restorative justice program, solving the problem. Because you can punish and you can keep apart, but if you don't go through that process of solving the problem between the two parties, it can happen again. So this district made a concerted effort under Dr. Jenkins' leadership to move us toward those two processes. Yeah.
So Dr. Jenkins, did you hear that?
Yeah,
Member Cober would love to hear back at some point.
Yeah, two things. It was called the School Justice Partnership. Chair and I have talked about that. We don't have a new one in place. We still have some negotiating on that language, but it was the district attorney, the chief judge, as well as all of our local law enforcement agencies signed an agreement that they would determine civil citations in every instance. I believe since then, John, there's been some legislative language added around civil citations to try to stop that over arresting of some of our youth. And once we get that renewed, we will certainly bring it to the board. We've just not been able to get all parties as they've changed. We have a new chief judge, we have a new state attorney, and so we are still negotiating through that with all of our law enforcement agencies to get the new school justice partnership put in place, and we'll certainly brief you on that. And then annually, there is a report that comes out around which agencies are doing more civil citations for youth versus actual arrest. Mr. Palmerini, you had thoughts on he's looking it
And
up.
Dr. Jenkins, thank you for that reminder. I think I've been so
We're waiting.
caught up with
It's still on my list,
COVID,
but
but thank
we've got a
you. Yeah.
glitch, though.
Yeah, no, I remember. There've been so many other pressing issues, but yeah, absolutely. All right, is there anything further, Dr. Jenkins, this board needs to do here today? All right, let me apologize for being late. I do not know how I had it in my mind. It was 1:30. But let me also ask Vice Chair, if I'm ever late and you can't reach me, please, by all means, when I
said you were on the way.
Oh, I went upstairs and Deborah's looking at me going, what are you doing here? And I'm like, I got 15 minutes or 20 minutes or whatever. So and I'm yelling, tell them to start without me. So please start without me, folks. And again, I will try to make sure that never happens again. Pardon me? Oh, gosh. And come to think of it, I think I spent some time talking to one of our CTE employees. That might have been on my way out, not on my way back. Anyway, I apologize. Thank you all. God bless. Great job, staff. Thank you so much, everybody. Meeting adjourned.
Thank you.
Thank you.
Thank you.